views and opinions expressed in this program are those of the participants and do not necessarily reflect the views of BronxNet or the program underwriters.
All right, well, coming up on this edition of Today's Verdict, the area of antitrust is interesting, but it's a confusing area of the law. Monopolies, price fixing, these are terms that we hear about but don't really necessarily understand. Well, tonight we have an attorney in studio who will educate our viewers as to the origins of antitrust and how our laws impact today's businesses. It's Antitrust 101 and is starting right now on this edition of Today's Verdict. Hello and welcome to Today's Verdict, the live and interactive show that gives you your legal rights and options. I'm your host and trial attorney, David Lesh. Well, Today's Verdict is always encouraging you to stay connected. Make sure to tweet us at Today's Verdict and hashtag Ask Today's Verdict if you have a question. Also, make sure to like us and follow us on Facebook at Today's Verdict and check us out at BronxNet.tv/Bronx Legal. And last, but certainly not least, don't forget to tweet me at David Lesh. Well, what is the purpose of antitrust laws? And how are you, as the consumer, affected? Well, joining us today to help us get a better understanding is attorney Stephen Fruit. Stephen, I've spent hours researching for tonight's show, and I have to tell you, I still don't understand very much that's going on with respect to antitrust. I'm very happy that you're here. Maybe we could just start with a little bit of the history of antitrust and what it even means, because it is a little confusing.
Well, you have an explosion of industry in the United States in the 1800s, moving into the late 1800s. And with that explosion of business activity, manufacturing, shipping, exports, you also had a concentration of industry and wealth and control. And often the mechanism that was used by some of the big business types, and you know these names, Carnegie, Vanderbilt, Rockefeller, J.P. Morgan.
I'm thinking railroads, is what I'm thinking.
Railroads, big banks, these were things, big oil, interconnected. And the means that were used to create an umbrella over some of these industries were trusts. Now, trusts means something different in different contexts.
It's not as you would think as antitrust, you can't trust somebody. It's almost like a document or some type of legal, some type of legal connection to somebody. So that's why antitrust, is that what they mean?
Yeah, antitrust means, at the time, it was a phrase that was coined because instead of a company getting extremely big and having many subsidiaries, the method that people used, the captains of industry, the robber barons they were called, would create complex webs of companies that they controlled under a trust. And a trust is just a way of saying control over different entities, property, money, in this case, companies.
All right, so now you're in the late 1800s, and we're finally starting to get control of some of the companies that are taking over. And are there any laws? What's the first law that shows up with respect to this type of regulation? Is it I know it's the Sherman Act?
The Sherman Act.
Okay.
The Sherman Antitrust Act was passed in 1890, and it was followed by other laws as well. Ultimately, the Federal Trade Commission Act, the Clayton Act.
But it's that first act, right? It's
Yes.
that Sherman Act that really establishes the United States as we're going to take a position here and we're going to try and prevent the Rockefellers and the Vanderbilts from cornering the market and really, in essence, setting a price that consumers don't have control over. Am I correct?
Yes, because there was an absence, there would be, in the worst case scenario, there'd be an absence of any competition. What the antitrust laws seek to do is to protect competition. And the theory of the antitrust laws is that if you protect competition, you ultimately benefit the consumer because the consumer does not get placed in a position where they have to pay high prices and no competitors can come in and offer services or products or prices that are also attractive.
And by the way, and here shows up President Teddy Roosevelt, and he starts using the Sherman Act as a as a fist in some respects and goes after some of these companies. Right? I think the oil companies.
Yes, Standard Oil is broken up as a result of the federal government. And Roosevelt, Teddy Roosevelt, becomes known as a trust buster.
And what people probably don't even know is that these oil companies, the Standard Oil became Chevron in California, Mobil, a lot of the other companies that are still around now, Exxon, but all were one big company at one time, and that was Standard Oil, and that's when President Roosevelt said, no, we can't do this anymore. We got to break you up so that there's more competition in the field. Am I correct?
Right, and this is not only ancient history. This is true. Most people know, they know the term baby bell companies, right. Different regional bell companies. Well, the government broke up what was known as Ma Bell, AT&T. They ran phones for the whole United States. And when they started to branch out beyond what they were in a regulated monopoly for basic phone service, the government stepped in and sued them, and they were broken up.
Which brings us to some of the statutes themselves. At least now we're starting to move with respect to the history of the laws here. I know we had the Sherman Act. Where does it go from there, really?
Sure. Well, the most important thing is the Sherman Act, and that prohibits two kinds of conduct. The first, Section 1, they call it, it prevents contracts or combinations in restraint of price. What does that mean? Yeah. That means an agreement to set a price or an agreement to rig a bid. Anything that gets in the way of competition based on price or service will run afoul of the Section 1 of the Sherman Act.
Okay.
So price fixing is automatically illegal. And by the way, over in our history, people have gotten together in hotel rooms, groups of people representing different companies, and they have met to fix prices, and they've gone to jail. So some of these laws have a criminal component, and the Sherman Act has a criminal component.
I mean, and from a very basic, view, you're basically getting together with a bunch of, you can say friends, but a bunch of people and say, look, let's just keep the price at X amount of dollars. This way, we're selling cell phones. It's Samsung and Apple, and everybody gets together and says, you know what, I have an idea. Let's make sure that none of us sell our phones for less than $1,000. And everyone says, that's a great idea. We'll all, at least profit in that way. And that's what we're really talking about, in terms of, it's colluding, it's getting together and fixing a price. And that's something the Sherman Act was certainly looking at, whether it's in a hotel room or wherever it is, and making sure that whoever does something like that, they go to jail.
Either they go to jail, or if the proof isn't, completely, obvious, then maybe it'll be a civil case, and the government will get remedies such as stopping the price fixing, an injunction, maybe financial penalties.
All right, let's get past the Sherman Act.
Okay, well, actually, second part of the Sherman Act, and this is big, is anti-monopoly. It says you cannot conspire to create a monopoly or attempt to monopolize or monopolize the market in a particular product or service.
Give me an example of what a monopoly would be like. Would you say Standard Oil was a monopoly at the time?
Yes.
Okay, so Standard Oil was the first real monopoly that we decided to break
certainly.
up. And then the baby bells, the AT&T, what was that? Was
AT&T.
AT&T, we broke up AT&T. So that's really the concept of a monopoly. One company that's just controlling the market. Is there a particular share of the market that would be considered to be a monopoly? Is it 50%, 70%, 80%, or does it really...
Economists argue about this all the time, and this concept changes over time. But usually, if a company doesn't have, well over 60% of the market, you really don't even look at them. But part of it is, do they have any competitors? Another aspect is, can anyone else get into the business, or do you have to buy such an extraordinarily expensive piece of machinery or land that no one else can get in? Sometimes being not as big can still allow you to be a monopolist.
It seemed like that Sherman Act was very strong. You wouldn't need anything else, but apparently there's been other acts.
Well, there are other acts because probably the most important other statute, and there are others, but we can't go into all of them. The Clayton Antitrust Act was very, very important because what it did, Section 7 of the Clayton Act said that if there's ever a transaction, like we hear about mergers and acquisitions,
right.
If there's a transaction that is going to, it could be a joint venture, anything like that, where the effect of the deal would be to substantially lessen competition in a product or service, then the government can review that, and now there are rules about notifying the government, and then the government steps in and they ask questions, and they can block it.
And when was that passed, approximately? Was that
I actually
early 1900s as well, or was that in the mid-century?
I think that it came in the first part of the century.
Okay, so that statute is like, well, we don't care about one particular company. We just don't want one company to merge with another. It's not just one company that's taken over. We're not going to let two to get together and combine and merge and become a monopoly. So that act was really preventing the two from getting together. I guess with that and the Sherman Act, we're finally getting some teeth in our ability to regulate business.
And people hear about this all the time.
Sure.
I mean, just in the last couple of weeks, it was announced the largest merger in the history of the world. Bayer, which we know from Bayer aspirin, but it's a big chemical company, offered to buy Monsanto for $66 billion. And the antitrust officials are looking at that and will look at that, and the companies know they will. I'm sorry, to take over Monsanto, if I didn't say that. And Monsanto is one of the largest producers of insecticides and crops and that sort of thing. So the combination will be an enormous company that has its hands in all kinds of chemicals and fertilizer and seed and variations of planting and things like that. And people are concerned about it. And there are other proposed mergers involving other companies like DuPont and Dow Chemical that also raise the specter that maybe an industry that now has 6 big players could have 3.
Could have 3, okay.
And then the regulators get concerned.
All right, well, we're gonna take a quick break but when we come back, I want to talk to you a little bit about ethically whether we think this is something that we want as a society. Do we want the market to just regulate itself? Where we're heading, all right? But we're not there. We have to take a quick break. Stay with us. I got so much to ask, Stephen. We'll be right back.
They said a bottle was just a bottle. That no one would ever notice me. But I knew I could be more. That one day, I would make people smile.
There's a shelter pet who wants to meet you. Meet one today. Visit theshelterpetproject.org. Adopt.
Wow, these are really good.
You act surprised. Practice makes perfect.
You don't have to be perfect to be a perfect parent. There are thousands of teens in foster care who don't need perfection. They need you.
Hey, look, it's those guys.
Let's go, Pearly Whites, man. Yeah. Boys, check it out.
Ooh, cute.
Are you good to try?
I'm fine.
Hey girl, what's up? What's the name? What's good? What's up?
What's happening? How many did you have?
I should be fine.
You should be.
Sir, go and step out of the vehicle for me.
Yes, sir. See ya, buddy.
Today, Sean's got a hearing. We'll see how it goes.
Good luck.
So turns out, buzz driving and drunk driving, they're the same thing. And it costs around $10,000. So not worth it.
It's not always easy being a dad.
Do you have panda asthma too? Does that run in the family?
This is the home of the most priceless kung fu artifacts.
But when you make an effort...
Dad, we're not supposed to touch anything.
Oh, sorry. Go long, son!
It's always worth it.
Whoa! Faster!
The smallest moments can have the biggest impact. on a child's life. Take time to be a dad today.
I am gonna get you. I'm gonna get you.
Call 877-4DAD-411 or visit fatherhood.gov to learn more.
Welcome back to Today's Verdict. I'm your host, David Lesh. We're always encouraging you to stay connected. Tweet us at Today's Verdict. Well, we continue the discussion of antitrust law here with the attorney, Stephen Fruit. Stephen, adding to the terms that I still don't understand, let's talk a little bit about predatory pricing. What do we mean when we say predatory pricing, and how is that somehow part of the antitrust discussion?
Sure. It has to do with monopoly. If a company has monopoly power, which we talked before is, more than 70% of the market, and there's really nobody who can keep up, no other company, that company may feel that it can drive all of its competitors out of business by actually pricing a product or service below what it costs the company to make. Now, you can imagine that you can't stay in business very long if you sell a product for less than it costs you, for a loss. But a company that's a monopolist could do that for a certain period of time until everyone else is driven out of business. That's what predatory pricing means. And it's an element of proof that the government can use, or I should say, private parties, other companies can sue a monopolist as well, in showing that it must be a monopoly because it can afford to engage in predatory pricing. The danger for the consumer is that when that period of predatory pricing is over and everyone's driven from the market,
up goes the price.
Exactly.
Right. And I understand, when you talk about private citizens bringing in action, that it's the government actually encourages this. They want the private sector to act almost as their own private attorney generals, sometimes regulating the market themselves. So it's something the government obviously probably wants, these private actions as well, because they can't go after all these companies. And I think as incentive, there is triple or treble damages, right?
There is treble damages. In fact, I think that the United States is one of the few countries in the world that allows treble damages or permits it and as an incentive for private parties. And when I say private parties, it could be sophisticated plaintiffs' lawyers who bring class actions on behalf of consumers or wholesalers or other firms in the distribution chain, or it could be just other companies.
And by the way, what kind of work do you do specifically when it comes to antitrust? Are you bringing the actions? Why don't you tell me, with respect to antitrust, what exactly do you do with respect to antitrust? Are you bringing actions in federal court? Are you bringing actions in state court? What type of actions are you involved with?
Well, our firm brings antitrust actions in state and federal court because each state has its own antitrust laws. We represent plaintiffs. I represented, with my colleagues, 4,000 independent pharmacies in an antitrust action against the brand name drug manufacturers starting in the 1990s, having to do with price discrimination.
You were also involved in the Microsoft litigation, am I correct?
In part two of the Microsoft litigation, after a new political administration came into power and settled the original Microsoft case, we got involved in opposing the settlement, part of our firm. And that was a monopoly case as opposed to a price discrimination or price fixing case. So we're on both sides of these cases. We bring the cases and we defend companies in these cases.
Other countries don't necessarily treat antitrust the way we treat antitrust. Am I correct?
Yes. I mean, for a long time, we were probably alone in the world in having antitrust laws. Canada had antitrust laws fairly early on. Because we won World War II, Germany and Japan had antitrust laws because their governments had to do certain things as part of Reconstruction. But ultimately, the largest player outside the United States today in antitrust is the European community, or the European Union. The European community is a part of European Union. And that would represent, almost 30 countries in obeying one European community law.
How do they compare to the United States? Are they stricter? Are they
It varies. There are times when our government has permitted a merger or an acquisition under that Clayton Act review, and the European community has actually given those companies a hard time and said no, not within our borders.
So what do you do if you're a country if you're a company that's actually competing internationally? How do you fight? Do you just fight it on different fronts? Is that
exactly? You have to satisfy different regulators, and if you can't satisfy them, then it goes to court. when the government, like for example, when the Justice Department or the Federal Trade Commission, which those two agencies share responsibility for approving mergers and acquisitions that pose possible anti-competitive threats, if they don't reach a settlement, then the companies, they have to go to court and sue to stop a merger, and that's part of the statute.
I know there's some recent cases that have been coming up. Certainly the one with the EpiPen, I think that's an interesting case. Is that a monopoly, this whole notion that a pharmaceutical company can really corner the market on a product that affects our health? Is that?
You know, it gets a little complicated because when you talk about pharmaceuticals, you have to talk about patents. And a patent is essentially a monopoly that's granted to an inventor for a certain period of years where they're the only party that's allowed to produce. So when you hear about a brand name drug, they have a certain number of years that they can exclusively sell the product. In the case of EpiPen, the substance, the epinephrine, is not actually any longer on patent, but the construction of the pen itself is. And so this company has some competitors who have their own invented pens, but for various reasons, those competitors are very weak or not in business right now. And so the maker of EpiPens, Mylan Pharmaceuticals, is pretty much the only game in town.
Well, that in itself really, isn't that over a 70-75% market share?
It is, but because of the patent laws, they're allowed to do that. Nevertheless, Attorney General of the state of New York has recently opened an investigation, given all the publicity about the $600 for the 2 EpiPens raising the price sixfold over the course of the last couple of years. The Attorney General of the state of New York has said he's looking into allegations that Mylan approached school districts and said, we'll sell you the pens, but you can't buy from anyone else for 2 years or something like that.
That's a little bit about the Microsoft. We'll sell you the computers, but you have to use our Netscape in the product.
Well, they didn't have Netscape. They had Internet Explorer.
Internet Explorer, okay. You're right.
Netscape sued them.
That's right. I'm sorry.
Right.
The Internet Explorer was bundled into the Microsoft software that you had no choice.
Right.
Okay.
And bundling is an aspect of attempting to monopolize.
All right. Another break? Okay. We've got to take another quick little break. Don't go anywhere, because now we're going to bring it home, and I'm going to ask you what specifically you do when you bring in action with respect to antitrust. Stay with us. We'll be right back.
Hey, did you know 2.4 million loving cats and dogs in shelters and rescues need our help to find a home? Let's go to the shelterpetproject.org and meet if you are in a shelter near you. Harlow. Oh, she's one great listener who loves to hear all your stories. My kind of cat. Cerulo is a sweet, goofy boy who's eager to please. Sounds just like another dog I know. So go to the shelterpetproject.org, search your local shelters and rescues, and go for a cuddle with your next best friend. Adopt.
There's a shelter pet who wants to meet you. Meet one today. Visit theshelterpetproject.org. Adopt.
When you're out there, there's no telling what you'll find.
I see it! I see it! Oh, look at you.
There are some moments only the forest can inspire. Find yours at discovertheforest.org.
It's me, Artie. Come see what I collected from the Creative Galaxy in my idea box.
Transform your world.
Will you help me make art?
Before you throw it away,
Hey, I have an idea.
think outside the box.
Go be amazing!
Give your cardboard box another life. Recycle.
Hi, we're back with Stephen Fruit, our expert in the area of antitrust law. Give us an example of maybe somebody who isn't running afoul of the antitrust laws currently on the books.
Well, I mean, one of the things you have to look at is if a company is just really good at what it does and it's figured out basically how to build a better mousetrap and nobody else is catching up for a while, that doesn't violate the monopoly, the antitrust laws. So for a time, Microsoft, for example,
which is very good at what they did.
They were not only very good at what they did, they were almost the only people in the market in terms of operating systems. Remember, the brain of your computer.
That's correct.
You can buy a computer, but you need an operating system. It almost always comes with the computer. Well, sure, there was Apple, but Apple was for a small segment of the market. So Microsoft succeeded because they got there first. And so they were not a monopoly because of their operating system. Where they got in trouble, or where the government thought that they got in trouble, was that they started to try to leverage their natural monopoly in the operating system, which was not illegal, into trying to force people to use their browser and not these other browsers that were starting to be created for searching the internet.
Very quickly, we have like 15 seconds. You got Clinton and you got Trump, okay? If one wins or the other wins, is antitrust going down or going up? Where are we heading?
Typically, if a Republican is the president, that administration will be more hands-off. They will be less likely to bring antitrust suits and more likely to approve mergers and acquisitions. Democratic administrations tend to be more activist. They will more likely go to court to stop a merger, and they are more likely to bring cases. Monopoly, price fixing.
All right, well, this has been wonderful. I expect you to come back after the election so we can see who was in office and whether or not it's going to absolutely affect particular companies in suit. But Mr. Fruit, thanks for coming.
Sure thing.
All right, well, that's all the time we have for tonight. I'd like to thank our guests for joining us, and of course, you, the viewers, for watching. If you have any part of the show that you want to see again, make sure to check it out at www.BronxNet.tv. Also, remember, if there's a legal issue or topic you'd like to see on a future edition of Today's Verdict, feel free to contact me at davidlesh@bronxnet.org or tweet us at Today's Verdict, and make sure to hashtag Ask Today's Verdict for myself and all of us at Today's Verdict. Always remember, know your rights, know your issues, reach a verdict. I'm David Lesh, and we'll see you again in 2 weeks with an all-new episode of Today's Verdict right here on BronxNet.
Adopting a new pet is a rewarding experience. And Shelter Pets makes super pets. Your new best friend will steal your heart, bring you happiness, and enrich your life for years to come. You can make a difference in the life of an animal. Adopt and bring home a Shelter Pet today. To find out more, visit theshelterpetproject.org.
Wow, these are really good.
You act surprised. Practice makes perfect.
You don't have to be perfect to be a pro.